Good afternoon. Happy Sunday. I've had a lot of comments in my comment section that an attorney has the audacity to agree with Chili DeCastro that Terry versus Ohio is a bad decision. Now, a bad decision is a subjective opinion, and you can have a subjective opinion that differs with Chili, and you can have a subjective opinion that agrees with Chili. And that isn't in and of itself good or bad. I mean, Chili might like chocolate ice cream and you might like chocolate ice cream. That doesn't mean that you agree with Chili on everything. And that doesn't mean that Chili's underlying rationale for liking chocolate ice cream is the same as yours. Now, I attempted to watch this attorney's video where he interviews Chili DeCastro, and I couldn't. I disagree strongly with a lot of his underlying assumptions and beliefs, and I'm not a big fan of race baiters, so I decided after about 10 minutes or so into his video that I wasn't concerned with his opinion on Terry v. Ohio. But here's my opinion on Terry v. Ohio. The Fourth Amendment, much like the Fifth Amendment and the Sixth Amendment, were designed to make it harder for the government to prosecute people. Their whole purpose was to make it inconvenient for the government, to place obstacles in the government's way from interfering with you and your rights and your freedoms and your liberties. And it was understood by the founders, I believe, that the Fourth, Fifth, and Sixth Amendments were going to make it more difficult to prosecute criminals. And not only would it protect innocent people, but it would protect criminals. And so, with that said, I think Terry versus Ohio is a bad decision, which is in a line of bad decisions, that undermine the purpose of the Fourth Amendment. The Fourth Amendment reads, quite simply, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, what the court has done, the Supreme Court, is they've split it into two sections. So you have the right to be secure against unreasonable searches, and warrants shall not issue but upon probable cause. So there's two sections. That's what the court's done. Now, I look at the Fourth Amendment a little bit differently. I see, first of all, a list of persons, houses, papers, and effects. And to me, that is a descending list in order of importance. Your person is the thing that is closest to you. Your person, your body, your bodily integrity is the most important thing that any person can have, is their own bodily integrity and bodily autonomy and freedom. Houses can get burned down and go away. Someone can seize your house. Someone can bulldoze your house, sell your house out from under you. And you can go on living and maybe even prosper. But your person, if you're put in jail, if you are shot, if you are detained, that's more personal. You get it? Your person is more personal than your house. You have a more interest in your house. Papers you have maybe in your house, maybe at work. But the things in your house are going to be more personal to you than papers at, for example, your business. And effects, that's just your things. Your things can't be seized. Your furniture can't be seized, etc. So I see that list as a descending list. And in my opinion, you can maybe disagree with this, any protection for a house should be afforded to a person. Persons should not have less protection than houses. And yet, based on Terry v. Ohio, they do, which I think is insane. And what is an unreasonable search or seizure? Well, in my opinion, since a warrant is unreasonable unless it's based on probable cause, that an unreasonable search or seizure is a search or seizure that is not based on probable cause. I don't see why probable cause should not be a basis by which reasonability is determined. And the court has gone away from that. The court has instead decided that, well, we're going to do a balancing test between the needs of the government and your right to protection from unreasonable searches. They've turned it into some weird balancing test. And balancing tests, you have to apply subjective values to things, whereas probable cause is more cut and dry. It's more cut and dry. More. It's not 100%, but it's more cut and dry. So let's start this off with Kylo versus United States, 2001 decision from the Supreme Court. In Kylo versus United States, the issue is whether or not the state had to get a warrant to see thermographic imaging. They were using a heat camera that looked at your house and would be able to see how much heat is emanating from each area of your house. They couldn't see through it necessarily, but they could see which rooms were hotter and which rooms were cooler. And the court in Kylo versus United States said, no, you need a warrant for that. You need probable cause for that. By saying that they need a warrant, the court is saying they need probable cause. Because no warrant shall issue, but upon probable cause. If they say you need a warrant, you need probable cause. Now, Kylo deals with a house and thermographic imaging, thermobaric imaging, something like that. I don't remember the exact term. Heat imaging. A thermal imaging device. They were looking at the heat signatures of a house. Your house has more protection than you do from searches and seizures. But let's go back in time. This is Boyd versus United States. It's an 1886 decision. This is the first case that I could find where it really deals with the reasonableness of searches and seizures, things that aren't based on warrants. And it talks about writs of assistance. A writ of assistance in English and American colonial history was a general search warrant issued by superior provincial courts to assist the British government in enforcing trade and navigation laws. Such warrants authorized custom house officers, along with the assistance of the sheriff, justice of the peace, or constable, to search any house for smuggled goods without specifying either the house or the goods. Search any house for some sort of contraband without specifying the house or the goods. And Boyd versus United States said that the great injustice that the founders were looking to prevent was a writ of assistance, where the sheriff, justice of the peace, or constable could search any house for smuggled goods without specifying either the house or the goods. And then we have Terry v. Ohio, where a police officer can search any person without specifying the person or the thing to be searched for. All he has to do is say that he has reasonable suspicion. He has to articulate a few facts to justify that position, that reasonable suspicion. And then he can grope your balls. Anytime, any place, All he has to do is articulate facts that would support reasonable suspicion. Tell me how that's different. In Camara versus the Superior Court, this is where, in my understanding, the court started using a balancing test. There were inspectors who wanted to get into a housing unit to inspect for housing code violations. They wanted to get into your house, and the court said it's a balancing test. It's a balancing test. The needs of the government to get in there and inspect versus your right to privacy. That's where it started. Then in Terry v. Ohio, it continued to be a balancing test. In Terry v. Ohio, they started looking at But here we deal with an entire rubric of police conduct, necessarily swift action predicated by on-the-spot observations of the officer on the beat, which historically has not been, and as a practical matter could not be, subject to the warrant procedure. Instead, the conduct involved in this case must be tested by the Fourth Amendment's general prescriptions against unreasonable searches and seizures. So they're weighing the needs of the state to do swift police conduct with your rights under the Fourth Amendment. And I don't understand why okay, so you don't need a warrant, or it can't be subject to a warrant procedure, but it could be subject to probable cause. And in order to assess the reasonableness of Officer McFadden's conduct as a general proposition, it is necessary first to focus upon the governmental interest, which allegedly justifies official intrusion upon the constitutionally protected interests of the private citizen, for there is no ready test for determining reasonableness other than by balancing the need for search or seizure against the invasion which the search or seizure entails. Why? Why do we need to balance the government interest? We understand it's obviously the government has an interest in apprehending criminals. I understand it. But you have to understand that this is based on being not necessarily a criminal. Where a police officer observes unusual conduct, which leads him reasonably to conclude, in the light of his experience, that criminal activity may be afoot. May be afoot. There doesn't have to have been a crime committed, and yet they get to detain you and search you. Does that make sense? They can't use thermal imaging devices to scan your house from the street, but they can detain you for suspecting that crime may be afoot without probable cause. And as long as they have reasonable suspicion to believe that you're armed and dangerous, they can pat you down. They can grope your balls. And somehow that's a reasonable search. Your right to be secure in your person, well, if the government has a need to catch criminals, then they get to grope your balls, and it's not unreasonable. And what does it lead to? There's a bit of a slippery slope. I don't know if you saw this, but on Chili's poster, he's very proud of having Buck versus Bell. Buck versus Bell is a decision where the United States Supreme Court said that you can force sterilize inmates who are, imbeciles or insane. You could force sterilize them. And you're like, oh, wow, that's terrible, right? But that came from somewhere. That came from Jacobson versus Massachusetts, where the Supreme Court said that a state can require you to get vaccinated, or else they could fine you if you don't. It went from there to Buck versus Bell. Some would argue that logic continued on to Korematsu. I don't think so, but some would argue that Korematsu, the ability of the government to place people in internment camps, i.e., incarcerate them without them having committed a crime, without even probable cause that they've committed a crime, without even reasonable suspicion they've committed a crime. You could go ahead and put them in concentration camps for the good of the state. Some would argue that that came from Buck versus Bell. Well, we know what came from Terry versus Ohio because they cite to it. United States versus Brignani-Ponce. The government can pull over your car. Reasonable suspicion. All they need is reasonable suspicion to pull over your car. In this one, it was a border patrol that they get to, around the border, they get to do a stop on you. And it's the same kind of thing. Terry v. Ohio, it's just a minor delay. No reasonable person would be upset with the cops stopping them for a few minutes to touch their balls and to ask them questions. Well, I like to think I'm a reasonable person and I have a problem with it. But then it goes to no reasonable person would be, it's a minimal intrusion for a brief stop at the border or near the border where they could pull you over and, just check out your car quickly. Yeah, it's reasonable, it's brief. And then you have Martinez Fuerte. And again, it's just a quick stop. It's just a quick stop. There's nothing interesting to it. Martinez Fuerte, oh yeah, they're just pulling you in to checkpoints, to suspicionless checkpoints. It went from you had to have reasonable, articulable suspicion that crime is afoot to all of a sudden it's just a checkpoint. And now we're weighing the government's interest in catching illegal aliens and finding smuggled goods and contraband. We're weighing that with not only your Fourth Amendment right to be free from unreasonable searches and seizures. Now we're also saying, hey, you've got to answer questions. They're going to ask you questions, and all you have to do, says the court, is just answer those questions, and then whoop, you'll go right on through. Just give up your Fifth Amendment right. It's a slope that I don't like. I don't like it. Benjamin Franklin famously wrote, "Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety." And I would posit to you that since 1968, crime has gotten worse. Since 1968, we are less safe in America. Since 1968, we've given up a lot of freedom and we've gotten no security in exchange. Now I get to go, every time I get on a plane, I get to go through and have someone scan underneath my clothes and or pat me down just for the privilege of getting on a plane. Oh, well, you could drive, John. You could drive. Yeah, I'm giving up my freedoms because there's still alternatives. And then there's those darn checkpoints. And well, you don't have to drive, John. You could walk. You can walk between states. Anyway. I don't like Terry v. Ohio. I guess that makes me a bad person because I agree with Chile. And that's fine. Thanks for watching. Have a great day.